All right, joining me this hour, criminal defense attorney and former prosecutor David Bruno and litigation trial attorney Rich Schoenstein. Gentlemen, great to have you on the show tonight. Great to see you guys again. All right, Rich, I'm going to begin with you, and we'll begin with the Dinkins case. The thing that jumps out, of course, is the fact that right at the beginning of jury selection, the defense decided they were going to go with a bench trial. Your thoughts on that choice by the defense?
Well, I totally understand, Michael, why they would go that route. You know, it's a very emotional case. It's very serious allegations. And I think the thought by the defense is we don't want any part of a jury coming in here and being emotional about it. Our only chance is to get the judge to look at the evidence and make a legal determination that the evidence does not establish the elements of the crimes as a matter of law. So you need somebody who would be dispassionate about it, who would be really technical about it. And I think defense counsel is relying on a judge to do that where they had concern that a jury would not.
Yeah, fair enough. And David Bruno, my question to you is, how does it, or even should it, change the way you go about trying your case? Now, I think for prosecutors thus far, it looks just like any other case. If a jury was in there, you wouldn't know the difference from what I've seen. But I can give an example from the defense's side. They didn't even give an opening statement in this case. Not something I think they would have done had this been a jury trial. So what difference, how do you approach it differently? And you've been both, prosecutor and defense attorney. Do you approach it differently at all?
Yeah, well, first off, Michael, I'm going to take the flip side of this. I mean, there's a big difference between convincing one person or needing a unanimous jury. And that's why frequently defense attorneys don't waive that, is because you also have an opportunity for a mistrial if there's not a unanimous verdict. How does it change? Yeah, that's an excellent illustration as to a defense attorney typically doesn't waive openings. You don't want to wait for all of that bad evidence to come in. It's prejudicing the jury, every single witness, and then you only get your opportunity to cross. And then last, you don't have to be as theatrical as you do in front of lay people. Certainly, we see a lot of the footage coming out of our jury trials where attorneys go above and beyond, try to be likable, try to be credible, and also the theatrics of it isn't necessary in front of the judge that's also the fact finder.
Yeah, they just get down to brass tacks and try to do the best they can with what they're dealing with. Again, I don't know what they have to deal with in the Dinkins case, but we'll be watching closely. Let's turn now to Randolph, Rich, and essentially you heard Chanley's interview with the defense attorney, and I thought when she was talking about what they were asking jurors in voir dire, and as all of us know, you're a trial attorney, David, you as well, when you're in voir dire, one of the best things you can do is begin to lay the groundwork for your defense to prospective jurors. And that's exactly what he was doing. He was asking them had they had experience with a traumatic event or some kind of home break-in, and this, of course, would lead them to help understand, or help the jurors understand, why there might be discrepancies in what is probably the worst piece of evidence against their client, that tape that he did. And so what he's doing there is sort of laying the groundwork for his defense.
That's exactly right. Voir dire is a very important and often understated part of the trial. You're not just getting information about the jury so you can make selections. You are indeed starting to argue your case. And also, Michael, you're trying to learn things about the jurors that will help you speak to them. You want to learn what they do, what their hobbies are, things that you might be able to hearken back to later in the case in order to address them. You're trying to make connections with the jurors so that they trust you and they feel good about your argument to them. You're really trying to accomplish quite a lot in voir dire, and it's an important part of this case. This is a very, this is a hard case. They said in the report, Randolph was nervous, and I don't blame him.
Yeah, no doubt. And they're actually looking for experienced jurors as well, David Bruno. What might be their thought process there?
Well, look, I mean, you have an opportunity to use peremptory challenges as well. So you want to get a feeling for who they are, even if it doesn't rise to a level of cause, that they can't be biased, they can't be objective, right? Because if they can show that they can't be objective, then you move for cause. And then if they're left on, you have to use your own instincts about peremptory challenges and striking. You know, let's not forget, Michael, very different case than the last time. because the prior jury was able to get allegations of a prior wife that was killed, and there was an argument on motive or this 404B type argument that bad actor is showing proof that he did this. Well, the court said, no, that was improper. So the prosecutor can't get that out. That was so prejudicial to the defendant that it required a reversal. Now they're left with just this crime scene and the defendant's statements on video and how it is inconsistent with the forensics. But it doesn't seem like the attorneys, the defense attorneys that were interviewed there are very concerned about that, given the spontaneity and also the perception and what individuals in that similar situation would have felt. And that's where they're going to explain inconsistencies.
Yeah, no doubt. And they also claim
without the prior allegations.
Yeah, no question. And they claim he was on opioids as well. Finally, only a couple of seconds left. Rich, question in Austin, in Georgia versus Austin Ford. They want to see his interview with the detective, again, telling his story, which we know now, and the defense clearly admits are lies.
Yeah, that's really a key to this case because the science doesn't prove the case one way or another. It's built around consciousness of guilt. And I'm not surprised the jury wants to take a look at what he said in that interview, exactly what his initial story is, and what he looked like delivering it. I think that is probably key evidence. No surprise they want to take another look.
Yeah, I wonder if they're looking at that to try to push them over the edge because no one can really say exactly what happened, but perhaps his lies can give them some clue and push them one way or the other.